Having welcomed you, I want to say how gratifying it is that there are so many fellow attorneys for whom the Code of Conduct is both interesting and relevant. This is a profession, and I'm a member of it. This is a profession which has very high standards and seeks to maintain them. And the Code of Conduct is one way of telling the public and your clients that the profession has those standards. It's also a way of reminding ourselves of what those standards are and how we can continue to uphold them. So I think the Code of Conduct is essential to our professional practice. So let's think about how we need to deal with the new Code of Conduct, that is to say, the Code of Conduct that will come into effect on the 23rd of February this year. I will consider three matters in increasing degrees of substance in today's session. Briefly, I'll answer why we have a new code. It's not that the current code is broken, but there are reasons why a new code was necessary. I'll then highlight for you the main changes. It's not all the changes, but the main changes that the new code makes over the old code. The reason I will do that is that I'm assuming that we're all familiar with what I call the old, but it's actually still the current code. So being familiar with the current code, what we all really need to do first up is be alert to the changes that the new code will implement when it comes into effect later this month. And then finally, and in the most degree of detail, I will work through those main changes with you to highlight what are our major obligations in relation to our clients and others under the code. So let's begin with why do we have a new code? Well, in fact, there's two reasons for that. The first is a factual scenario of which we're all familiar, which began in the end of 2014, when we saw the first of the public listings of groups of attorney firms. Rightly, the profession asked itself, and the board asked itself, does this new scenario require any changes to the way the code should operate? And to that effect, the board in the second half of 2016 began a review. They invited me to assist them with that review, and I'm very honoured that they did so, and I have enjoyed the process very much. And therefore, one of the reasons we have a new code is to, in fact, deal with that new scenario of publicly listed groups of practicing firms. But there's another reason we have a new code, and that is that, as we all know, we are now a trans-Tasman profession to the extent to which we're patent attorneys. And that profession, whilst agreed back in 2013, only took effect just under a year ago. One of the consequences of that taking effect was there are transitional provisions regarding the Code of Conduct that applies to trans-Tasman patent attorneys. Up until the 23rd of this month, trans-Tasman patent attorneys are subject to the current code, which is the Australian code, the 2013 code. But it was required of the board that within 1 year of implementation of the trans-Tasman profession, there be a review of the Code of Conduct to ensure that it was appropriate for the trans-Tasman profession. Therefore, there are three types of changes that have been made in the new code. Firstly, those which are consequential upon the profession being a trans-Tasman profession. Secondly, those that are necessary to deal with the scenario of publicly listed groups of firms. And thirdly, any other enhancements that can be made to the existing code to ensure that it's appropriate going forward. What are the main changes? Well, you can see in front of you the table of contents from the 2018 code. And I've highlighted here the provisions which I think contain the more significant of the changes that have been made. There are some new definitions which you'll need to be aware of. There are guidelines to the code. That's something new. The previous or current code has notes scattered throughout it. The new code has separate guidelines, which I'll explain in a moment. And then there are a group of obligations on attorneys: communication, disclosure, confidentiality, loyalty, conflicts, independence, and ownership, all of which are either reworked and elaborated from the current code or indeed new over the current code. So I'll work through those in that order as we go. If you have questions about anything that I say, please use the Q&A box to pose your question, and as I say, we'll either deal with it live or offline later. Let's start with the new definitions. Importantly for us, because we all have clients, that's why we're professionals, the code defines a client and indeed now defines a former client. I don't think there's anything radical about the definition. I'm confident that's how we all understood our client to be. That is to say, the person on whose behalf we're undertaking the work that we're doing. And self-evidently, a former client is a person on whose behalf we were once but no longer are undertaking work. The guidelines contain some elaboration of the concept of client, just to make it crystal clear where an attorney is receiving their instructions not from the person whom they're ultimately doing the work for, but some other intermediary, typically another attorney, say a foreign attorney. The guidelines make it quite clear that the client is not the foreign attorney giving the instructions. The client is the ultimate person for whom the work is being undertaken. Another new and very important concept that the definitions deal with is that of an ownership group. An ownership group is a group of attorneys and indeed other entities, ancillary businesses, which I'll explain in a moment, that have some degree of common ownership or common control or both. Ownership group is defined in two ways. For attorneys and ancillary businesses that are incorporated, they will be part of an ownership group if they constitute the concept of associated entities, as the Australian Corporations Act of 2001 defines that concept. Now, that concept, of course, doesn't apply to unincorporated entities, and the second part of the definition deals with those. Where the entities are not incorporated but are operating in combination, they are within the concept of an ownership group if they would have satisfied the definition in the Corporations Act had they been incorporated. So the upshot is that corporations that are associated entities under the Corporations Act are part of an ownership group, and their equivalents, to the extent to which those entities are not incorporated, are also part of the concept of an ownership group. That is elaborated and explained in the guidelines, as you can see, and it refers, of course, not just to the associated entities where they're attorneys, but indeed where they're ancillary businesses. And so I turn to the final of the new definitions in the code that I want to speak about, and that is this concept of an ancillary business. Rightly and positively, the profession is evolving towards offering complementary services. That is to say, services that are complementary or ancillary to the traditional services of a patent or trademark attorney. Those ancillary businesses are to be treated as part of an ownership group, even though the ancillary business itself is not an attorney or an attorney business. And the significance of all of that becomes clear as we get towards the end of this webinar, where I talk about the concepts of independence and the significance of that for duties to avoid conflicts of interest. And as you can see, the guidelines explain in plain language what type of business is ancillary, and that includes businesses providing services of the type that you can see there: commercialisation, management, etc., of intellectual property. I want to talk a bit about the guidelines now. These are new. The current code doesn't have them. This code that comes into effect later this month does. The code itself provides that the board may publish guidelines, and indeed guidelines have been published. So if you haven't done so already, you should download from the TTIPAB website the current guidelines. These are reasonably detailed clarifications and elaborations of the sort of more legal and statutory language that you find within the code. I've just been asked a question online: does an ancillary business include law firms? It seems to me that it would be most likely within the definition of ancillary business. If we go back and have a look at that definition, we can see that it's one that provides services that a client of an attorney firm might well choose to use. So even though the guidelines don't mention legal, it seems to me that in principle, legal services that are ancillary to the attorney's professional services would indeed be within the definition of ancillary business. Thank you for that question. So just to finish on the guidelines, you can note that the subsection 2 explains that the guidelines are informative, illustrative, not exhaustive. So there's no suggestion that the guidelines cover every possible scenario that can arise, and they're not binding. However, the point of having them is that they are indeed supposed to help us, as well as the board, understand what is intended by the various code provisions. I now turn to the first of the substantive obligations that the code imposes on us as attorneys, that is somewhat different from the obligations that the current code imposes upon us. And that is about communicating with our client. Section 16, subsection 1, sets out the various matters that an attorney needs to communicate with their client about before undertaking any work. Self-evidently, prior means before, and here any work means any work. Now, as it happens, if you're doing work of the type that you've previously done work for the client and you've complied with this guideline, this provision, then unless that new work is substantively different, you will have already communicated with the client about these matters. But you do need to check at any stage when you're undertaking any work, have you already told your client about these matters? The first three of the matters are ones that the current code, the 2013 code, obliges attorneys to communicate with their clients about. That is to say that the client is told that the attorney is a registered attorney and bound by the code. The client is told about the registered attorney's competency and how that will be drawn upon from others if necessary. And importantly, the procedures, the timing and the likely cost of doing the work that is envisaged for the client. There are two other matters which are new to this code that attorneys need to draw to their client's attention, and that is whether or not they're incorporated, and if so, whether they're a public or private company, and whether they're a member of an ownership group, and if so, who are the other members of that group. Those matters, as I say, are new to this code, and they have been triggered by the factual scenario that I mentioned at the beginning, that is to say, of having now listed on the stock exchange groups of attorney firms held by a company. It's not the case that you always have to inform these matters to the client. Subsection 2 of Section 16 says that the first 3 of those matters in subsection 1 don't have to be communicated to the client if the work being done for the client is via another attorney. That is to say, if you're receiving your instructions from another attorney, a foreign attorney or other attorney, then it's not necessary to tell the ultimate client those matters. And subsection 3 of Section 16 says it's not necessary to tell the client of the final 2 matters if you're dealing with the client through another attorney and you've previously told that attorney of those matters. So once told the instructing attorney that whether or not you're incorporated, and if so, in what way, and whether you're a member of an ownership group, and if so, who else is, once told to that attorney from whom you're receiving instructions, you don't need to keep telling the attorney that. And indeed, subsection 4 highlights the fact that, however, where you have previously communicated matter that you are required to do so, and that matter has changed, that is to say there's been some material change to the information previously communicated, then the new situation needs to be communicated to the client or the instructing attorney, as the case may be, in writing. And guideline 16.2 gives some illustration about when a change may be materially different and need re-notification or notification of the new circumstances. And that would include where the competency that the registered attorney previously was applying for the client is different from the competency that the registered attorney now needs to apply to the client. Put very crudely, very basically, if, for example, in the past, the registered attorney was applying the competency of a trademarks attorney and then for the new work is applying the competency of a patent attorney, that's a material difference, and that fact needs to be notified to the client. Similarly, if matters of timing or procedure or cost for the new work are materially different from the procedures, timing or cost of the work previously done, then those new matters of procedure, timing or cost need to be notified to the client or the instructing attorney, as the case may be. I'm just reading a question, if you bear with me for a moment, that's come in, except it's disappeared. I'll come back to that if need be. Finally, the communication provision has a section in the guidelines about the transition from the position we're currently in to the new code and going forward. There may be some attorneys incorporated and or a membership of an ownership group who haven't to date notified their client of that fact. Once the new code comes into operation, they will need to do so, and the board requires that they do so within a reasonable time, and in particular, no later than 3 months after the code commences. And as I mentioned previously, the new code will commence on the 23rd of February this year. I'll turn now to another obligation. This one I think is new, at least expressly, to the code, and that is the obligation to make disclosure to the client. Section 17 says that unless prohibited, either by the code or by law, an attorney must disclose to the client all information of which they are aware that is materially relevant to the work being undertaken for the client. It simply means that if you're aware of information that is materially relevant to the work you're doing for the client, you can't keep it to yourself. You do need to disclose it. The client needs to be aware of this materially relevant information, unless it's, say, confidential information or for some other reason the law prohibits you from disclosing it. So you can see that Guideline 17.1 says, that is to say, a registered attorney must not withhold materially relevant information from a client unless, as I said, there's a reason in law for doing so. And Guideline 17.3 reminds us that although the Section 17 obligation is limited to individuals, and indeed, if you want to know why it's limited to individuals, the guidelines explain that, primarily to do with the fact that really knowledge or having information in your possession is most easily conceived of as being that which is relevant to an individual. Nevertheless, attorneys that are incorporated or that have staff are liable for acts of individual attorneys. So the reality is the obligation falls on individual attorneys, but by virtue of the responsibility provisions of the Code, incorporated attorneys and those who employ will have to take responsibility for the acts of individuals. I've been asked a question regarding the communication obligation and about whether or not the company is incorporated, and it's whether is specifying that the firm is a PTY Ltd company sufficient to inform the client that the firm is a private company, or more is required. Fair question. It probably depends on who the client is. Clients in Australasia would no doubt understand that, but clients elsewhere in the world may not. On these matters, I think one should be err on the side of fuller communication, fuller explanation than less. I don't think there's any advantage really to be gained by trying to sort of keep that information less than fully explained. So for what it's worth, my suggestion would be I would elaborate that. Therefore, when a client who's perhaps not familiar with the way Australasian company law designations operate, they have made it clear to them that this is a corporation that is either publicly or in this case privately held. Let's turn to the obligation of confidentiality. This is, of course, an obligation that always exists in the profession, and reference to it was made in the current code, but the new code has an express and freestanding provision about its operation. And as you can see, the obligation is that you are not to disclose or allow others to disclose, you're not to use or allow others to use a client's confidential information unless the client has consented to that. Now that, of course, is subject to the unless permitted or required by law, but putting that aside, the effect is that you can't disclose client confidential information unless they agree, and in general terms, as a rule of thumb, client confidential information is that which would not be generally available to other parties. So as you can see, the guidelines here both elaborate what it means to maintain confidentiality and clarify and elaborate what is confidential information. And out of an abundance of caution, but I think helpfully, the guidelines highlight client-specific financial information, including that it might have been generated by the attorney themselves. In your business, you may, as a result of your dealings with the client, generate financial information about the client that's specific to the client. Most likely that is client confidential information, and the Section 18 obligation about maintaining confidentiality will therefore apply to that. Let's turn to a suite of obligations under the heading of loyalty, which is really about loyalty to clients and avoiding conflicts, and ultimately we'll get to what to do about conflicts when they arise. The first subsection of Section 19 makes an express statement about a reality, which is that attorneys are in a fiduciary relationship with their clients, and as a result, they do owe a duty of loyalty to their clients. The remaining subsections of Section 19 elaborate what those duties are. And you can see the first of those in subsection 2 is what's sometimes called the duty interest obligation. And that is to say, an attorney must not prefer their own interests over the interests of a client. The guidelines in paragraph 19.2 take text that is in the current code and makes it clear that current code text is to be applied when considering what is an attorney's own interest. So the guidelines make clear that for the purpose of assessing what constitutes the own interests of an attorney, it includes the interests of a business partner or business associate of the attorney. It also includes the interests of family members, dependents and friends of the individual attorney. So just to make it crystal clear, I'm sure it is the case that as attorneys we all see it this way, but by virtue of having clients and therefore being in a fiduciary relationship with clients, is a paramount obligation that we do not prefer our interests over theirs, and our interests include the interests of others with whom we are very closely associated, either in a business or in a familial or personal sense. Subsection 3 sets out a different obligation, and that is an obligation of an attorney not to prefer the interests of one client over the interests of another client, sometimes called the duty obligation, the obligation not to prefer one of your duties over another of your duties to your clients. The guidelines in paragraph 19.3 respond to some concern that have been expressed in relation to the draft section of the code, which was, well, would we be preferring the interests of one client over another if we chose not to act for one of our clients in a certain matter on the basis that another of our clients doesn't wish us to do so because there is not actually a legal conflict but a commercial conflict of interest between those two clients? And the guidelines make it clear that that scenario alone doesn't constitute a breach of preferring the interests of one client over another. So you are entitled to choose which of your clients you're going to act for or to continue to act for. But what you're not able to do is, whilst acting for multiple clients, is to actually prefer one of them over the other in the way that I'll elaborate in a moment. And indeed, it's subsection 4 of section 19 that elaborates that scenario. It says, subject to the following subsection, an attorney can't act for one client in a matter knowing that the interests of that client are adverse to the interests of another client unless some conditions are satisfied. And there are two conditions that need to be satisfied. The first is that both of the clients have given informed consent to you doing so, and indeed have done so in writing. And secondly, that where confidential information about the other client, the one that you're proposing to act, if you like, against in this matter, or get in adverse interest of, the confidential information of that client is protected from being accessed by the people acting for the first client. So that is to say, so long as an effective information barrier has been established. If both of those conditions are satisfied, that is to say, there is an effective information barrier, sometimes called a Chinese wall, in relation to confidential information, and if both clients have in writing given their informed consent to the attorney acting for one of them, then the attorney may do so. Otherwise, the attorney is not able to do so. The guidelines talk about informed consent and an effective information barrier. Guideline 19.4 refers to the fact that there is indeed a definition in Section 4 of informed consent. And essentially, informed consent will have been given if the client consents with knowledge of all the information that is reasonably necessary and legally possible to be provided to the client so that they can make an informed decision. That guideline recognises that there may be some information that you can't give to the other client, for example, because it's confidential information of some other client. So that's what the legally possible part of the definition is doing. And the guideline also tries to recognise that it's a reasonably necessary qualification over the information that needs to be provided to ensure that the standard is not impossibly high for an attorney to comply with. But given those qualifications, it is necessary to give all the reasonably necessary and legally possible information to the other client so that its decision about whether or not to consent to you acting against it is one that the Code would consider to be an informed decision. The guideline also discusses the concept of an effective information barrier, and somewhat self-evidently, I think it says an information barrier is effective when it ensures that the confidential information isn't accessible by those who are acting for the other client in the matter against the client whose confidential information is being held. Subsection 5 is very important because it is a modification of what was just said in relation to the situation where the matter is such that the matter in which the interests of one client are adverse to the interest of another client, where that matter is in fact a proceeding before a court or similar body or an intellectual property office. In that situation, and I'll use the shorthand, if I may, of contentious matter, in that situation where it's a contentious matter and the attorney is seeking to act for one client whose interests are adverse to those of another, the situation is that the attorney can't do so. That is to say, it's not appropriate and not permissible under the Code for an attorney to act in a contentious matter for one client against another client of the attorney. The guidelines in paragraph 19.6 elaborate what sort of matters are, to use the label, contentious matters for the purposes of this provision. It doesn't include examination of a trademark or standard patent application before the Intellectual Property Office, but it does include the other matters that have been set out and highlighted there, each of which, as you can see, are within that sort of common phrase of being contentious, where indeed one party really is acting against another party. So you need to look at the guidelines to know whether or not you have the sort of matter that subsection 5 of section 19 applies to. And if you do, then you are not permitted to act for one client against another client in such a matter. Let's turn to a different situation, not now about current clients, but about former clients. Subsection 6 of section 19 addresses the scenario where attorney is looking to act for a client in a matter that is adverse to the interests of a former client. The attorney can do this so long as the conditions that are specified are satisfied. And those conditions are essentially this: so long as no confidential information of the former client is held by the attorney, or if confidential information of the former client is held by the attorney, then so long as an effective information barrier is established. Let's turn to the express obligations dealing with conflicts. Of course, loyalty is about avoiding conflicts, or about, more accurately, it's about saying when a conflict does or doesn't arise. Section 20 deals with the situation, or deals with the obligation, which is that all attorneys have on them, which is they must take reasonable steps to avoid conflicts. And in particular, therefore, they must avoid conflicts between the registered attorney's own interests and those of a client, and they must avoid conflicts between the interests of one client over another. You might say, well, that's self-evident because there is an obligation to have these duties, and if these duties conflict, then that would be inappropriate. And guideline 20.1, perhaps self-evidently, hopefully self-evidently, tells us that one way in which an attorney can take steps to avoid the creation of actual or potential conflicts is, of course, a conflicts check. So I'm confident this is what attorneys do, but for the sake of certainty, let's make it quite clear. Conflicts checks, that is to say, checking for the potential of conflicts, do need to be undertaken prior to accepting work from a new or prospective client to ensure that undertaking the work for that client would not, in fact, lead to a conflict with the interests of an existing client. Because as we know, under the provisions of Section 19, an attorney can't prefer the interests of one client over another, and Section 20 says the attorney must take reasonable steps to avoid that potentiality arising. Subsection 2 then says, well, in the event that a conflict situation has arisen, what must an attorney do? And the answer is the attorney must take, as soon as practicable, all reasonable steps to resolve the conflict. The guidelines attempt to give some assistance here. They point out that where the situation that's arisen is about a conflict between the interests of two clients, Section 19 explains when the attorney could and could not act for one of the clients against the other. And it also says, importantly, that where the conflict about which the attorney has become aware is a conflict between the attorney's own interests and that of the client, it may be that, in fact, the attorney simply can't act. The sort of the common law about this with professionals like lawyers and preferring their own interest over those of a client is typically along the lines of you can't do it. You can't even say, oh, I got my client's informed consent to do it. It may well be that, in fact, you simply can't do it. And the guidelines refer to that likelihood. let's turn to the issue of independence, which is of particular significance, or indeed is of relevance, direct relevance to the ownership group scenario. You'll recall that I mentioned the definitions have introduced a concept of an ownership group. In very simple terms, it's where there are groups of attorneys which have a degree of common ownership or control, or both. Section 21 is very important if you're an attorney who's a member of an ownership group. And indeed, of course, it also applies, as we saw earlier, to ancillary businesses. So not just to other attorneys in the group, but to ancillary businesses within the group. And what it says is that where an attorney is a member of an ownership group, a client of any member of the group will be treated as a client of the attorney to the extent to which the attorney is not independent of the other members of the group. And subsection 2 goes on to explain, for the purposes of that provision, what it means to be independent. And it says that a member of an ownership group will not be regarded as independent of any other member of the group unless the attorney operates independently in the provision of attorney professional services. So we're going to turn in a minute to what attorney professional services means, but just to get the concept clear in our head, as I say, it's a very important one for those who operate in groups. Where you operate in a group, in a sense, the client of one will be treated as the client of all, unless those members are operating independently of each other. And the subsection 2 explanation is that you will not be operating independently of each other if you're in a group, unless the provision of attorney professional services to clients is undertaken independently. The guidelines attempt to give some guidance about what it means to be attorney professional services. So the guideline 21.2 says that attorney professional services are typically the client-facing services provided by the registered attorney, and that therefore includes the provision of advice about and the prosecution of patent trademark applications. Given that they're attorney professional services, then independence is required, so that, or without independence being in existence, the clients of one member will be treated as the clients of other members. And that therefore requires that typically the professional staff, or at least the staff who are providing the attorney professional services, are not shared. So it would not typically be independence of operation to have common professional staff amongst members of a group, at least common professional staff providing attorney professional services. And it would also not be indicative of independence of operation if client confidential information was able to be accessed across members of the group. Now, that factual situation is contrasted with what guideline 21.3 talks about in terms of back office activities. The guidelines recognise that groups of attorneys may well share some staff and some functions, and so long as those staff and functions aren't delivering client-facing, if you like, or attorney professional services, the fact that they're being shared does not as of itself mean there is no longer independence of operation amongst the member firms of the group. But the guideline reminds us, and it's importantly, and the board is particularly sensitive to this, so you can read where you see these sorts of reminders. The board is really saying to us as attorneys, be very careful here. It's one thing to share back office services and say that we're operating independently because our client-facing services are independent. But particular care is required with respect to confidential information. So the reference in Guideline 21.3 is back to the Section 18 obligations about confidential information, and the board, again, sensitive, saying, and in particular, client-specific financial information should not be shared across members of a group if those members wish to maintain their operating independently. Subsection 3 of Section 21 is a really important twist on the loyalty obligations that we discussed earlier. And what it says is that where the clients of one member of an ownership group, where one member of an ownership group is acting for a client against the interests of another client of another membership group member, then even if the parties would, even if the members are operating independently and the deeming of the client of one to be the client of the other does not apply, nevertheless, the attorneys can only act in that way where the matter is contentious if the clients have given their informed consent to do so in writing. So put another way, where independence is actually occurring amongst firms in a group, nevertheless, where one member of the group wishes to act in a contentious matter against a client represented by another member of the group, then that's only permissible so long as the clients have been told that the representatives of each client are members of this ownership group and the clients have consented in writing to that situation occurring. And the final obligation I want to talk about today, before we open it up more generally for questions, is about the obligations on group ownership firms. The Code recognises expressly that an attorney may be a member of an ownership group. That's reality, and in principle, so long as the members of the group comply with the Code, and in particular those provisions that are specific to them, that's totally acceptable. But there is an obligation on members of an ownership group, and it's in addition to the Section 16 obligations about communicating with clients. There is an additional obligation on members of an ownership group to inform the public of that fact. In particular, the fact that the attorney is a member of an ownership group and the identity of the other members of that group have to be published, have to be clearly disclosed to the public. And the guideline in paragraph 23.2 says that it's such that one could reasonably expect that the means used to communicate that will indeed come to the attention of and be understood by the public. So this is not a situation where hiding the information away is going to be acceptable. The reality is the Code requires the public to be able to ascertain that attorneys are, firstly, members of a group where they are, and secondly, ascertain who the other members of that group are. And I would exhort the members of the profession operating in groups to use a very high degree of transparency here. The Code requires it, and in any event, it's appropriate for our profession to do so. So, in conclusion, let me observe this. At the risk of sounding somewhat patronising, I certainly don't intend to be, but I may be seen as to be so. The Code is a friend of the profession. It reflects the very high standards that we as professionals seek to and very usually do meet. It tells our clients, and to the extent to which the public wants to know, that tells them what our obligations are. But also, of course, it's helpful for us to have, because if in doubt about whether or not we're acting appropriately, the code gives the appropriate provision, and the guidelines hopefully elaborate and make clear what that provision is. So, although it's true that the code is used by the board in determining when attorneys have or haven't complied with their professional conduct obligations, we shouldn't see the code simply as a punitive piece of legislation. Rather, it is actually legislation to help us all in achieving what we seek to do, which is to perform at the highest possible professional levels. So I thank you for your participation today, and I mention for your benefit that the slides and the audio recording of this will be available after the event, and in the remaining time, and we have some time, I will seek to answer any questions that I haven't yet done so, noting that other questions that I don't address will be consolidated and a response to them published subsequently. Now, if you just bear with me, I'll look to see some more questions that come in. I've been asked a question about disclosure, which says, the question says this: is it sufficient for the disclosure obligation if the relevant information required under Section 16A to E is included in the standard costs agreement used? I think the short answer is yes, as long as that is indeed what it discloses. So that would typically be the way an attorney would disclose that information to a client. It is in a letter of engagement or a standard costs agreement. I've been asked a question here. Let me just read it and I'll read it out to you. Attorneys move between firms in the course of their career and bring with them client knowledge from their previous firms, and that, of course, is reality. Does an attorney coming into a firm suddenly create a conflict of interest if the incoming attorney acted for a competitor of clients in his new firm? I think it doesn't immediately create a conflict of interest, but it does immediately create a situation where the attorney needs to turn their mind to and ensure that they do comply with the code. Now, just to remind ourselves, one of the obligations is to avoid situations of conflict of interest. But I think in the fact scenario as stated, that alone isn't a conflict of interest per se. However, the attorney does need to be aware that a conflict of interest, actual or potential, may arise, and then they would need to act appropriately in that situation. Of course, they'd also need to bear in mind that if the information they have about previous clients is confidential, then they're under the confidentiality obligation, and it's not appropriate to start sharing that information just because you're now in a new firm. So to summarise an initial answer to a quite important and complicated scenario that possibly would need specific elaboration, merely changing firms and bringing with you in your head information about previous clients where those clients might be in commercial conflict with the clients of the new firm per se doesn't cause a conflict, but the situation in which it would, I think, most likely do so is where you have information that's confidential about that client. And in that situation, you can't disclose or use, which means if you are then asked to act for the new client of your new firm against the interests of your former client, you have confidential information. And unless you could establish an effective information barrier, then you would not be able to act against that former client. And if you have it in your head, that pretty much means you, the individual attorney, can't then act in the matter against your former client because you can't well, I don't think I could insert an information barrier in my head. And if any of you can, you must one day inform me how you managed to do so. I've been asked, please explain why the obligations on communication are important. I'm not sure if that's a sort of an indirect way of suggesting they're not, or whether it's a question generally about why communication is important or why those particular obligations are. So apologies if my response doesn't quite hit the point as intended. But they're important for a couple of reasons, but let's start with it, as we always should, from the perspective of a client. It's very easy for us to think, we know what we do, and we know how we're going to do it, and we know things like how long it'll take and what we're going to charge and why we're capable of doing it. But a lot of that isn't clear to clients, especially when they're new. So it's important that clients have those pieces of information that Section 16, subsection 1 specifies, told to them. Basically, it seems to me you can't go wrong having a higher degree of disclosure. So communicating fully and clearly with your client, I think, is very good, because the reality is clients probably don't know as much as you would like to think they do. So that's one way in which it's important. Another way, which may be the substance of the question, is what's different over the obligations in Section 16 in the new code versus the current. And here I just highlight again that it's the D and E, paragraph D and E obligations that are new, and they're about incorporation, because of course incorporation is still relatively new in the profession and clients aren't necessarily recognising that their attorney is incorporated, and that has some consequences for them potentially, and especially about groups. It is even more relatively new that attorneys are operating in groups, and clients deserve to be informed of that as well. I'll just see if we've got a question that can be answered in our remaining minute. I think that's it. We've reached our allotted time. So again, I thank you for your participation. Note that the slides and the recording will be available to you later, and also responses to questions that I haven't been able to address to date or that are coming in the foreseeable future will also be published at the end. Thank you very much.